Okay, good afternoon, everybody. Welcome to the webinar today being February 16th, 2022. I am honored to have with me Gene Goldstein with PEO Advisory Services. Most of you know me. I'm Gordon Berger. I'm with the law firm of FisherBroyles. And today we're going to talk about PEO client service agreements. Before we get started, as I mentioned, this is being recorded. I will have this video available on my YouTube channel in a few days. So if you have colleagues who happen to miss the opportunity to participate live, they'll be able to listen to the re-recording. And with that, we're going to get started here. And Gene, go ahead and introduce yourself.
Everyone, for those of you who I haven't met before, it's nice to meet you via Zoom. I'm Gene Goldstein. I am the principal of PEO Advisory Services. I am a former chief accounting officer, chief operating officer of a PEO in New York. I was there for about 10 years, and now I work with PEOs at all stages of their business cycle, as well as all sizes, working with pre-startups through to experienced PEOs on anything, rather than repeat what's on the screen, on anything finance, operations, compliance, payroll, taxes, accounting, you name it. The only thing I don't work with my clients on is actually selling your PEO to small businesses. That is not my forte. And I have been doing this side of the fence for about 5 years now.
And on the screen, you should be able to see all the various services that Gene offers to PEOs.
Thank you, Gordon.
And many of you know FisherBroyles is actually an international law firm. We are covering the United States pretty well, but we have offices overseas in London, and we do international practice. But as you can see here, we're a full service law firm. So we pretty much do everything. And when people ask me, what do you do, Gordon? And I explain, I do all things PEO. It might be regulatory, labor and employment, contracts, anything that really you have a need for in the course of operating a PEO. But today we're going to limit the conversation on all things PEO related to all things client service agreements. So Gene, you want to kick us off here?
Sure. The way Gordon and I thought about this is Gordon is more of the dot your I's, cross your T's kind of what has to be in the service agreement. And my point of view is more from an operational point of view. We've got this client service agreement. What do we do with it? How do we store it? When do we update it? What triggers a change? Whether it be an individual client that we need to get a new service agreement from, or maybe it's a sweeping, I became CPEO certified and I need to add an addendum. And how do I manage the ins and outs of operating with this client service agreement? So that's just a little background on where we're each coming from, and kicking it off for all of you who haven't heard. If you've spoken to either Gordon or I at any time about CSAs, we have said that your CSA is the single most important document in your arsenal. As a PEO, there is, in order to mitigate risk, your CSA is there to protect you, both risks that you know of, whether it be a gray area where we just want to make it clear as to who's required to do what in this relationship, or maybe an unknown risk. The CSA really outlines that and protects the PEO. Gordon?
Yeah, and so there's several components, of course. There's what I call chocolate and vanilla. So there's things you could pick a flavor of. There's certain things that as counsel, I want to see in there. And that's basically 3 years of experience of things that go wrong when they're left to slip through the cracks, for instance, as well as, where you have certain requirements that you're compelled to put in by a regulator, like if you're a certified PEO, or if you're dealing with a state that regulates PEOs. Those are items that you're going to have to contend with. Another way to look at it is that the agreement needs to say what it is and what it isn't, and it needs to say what you do as a PEO, i.e. what services you're going to provide, and what you're not going to provide, or what you're going to share with your clients.
Right. One of the things I'd like to point out here, in my experience, is we need to make sure that the CSA that you have, the salespeople are out there selling what you're actually, the services that you as a PEO are actually providing, and that whatever it is they're selling matches what we ultimately put in the CSA, right? Because there are some components of our services that we will provide to some clients, but not others. And we need to make sure that we are matching the reality of what we're providing, i.e. starting out with what our salespeople are promising, that is what is reflected in our CSA. So for example, a perfect example is way back when I was in the PEO, we had our salespeople telling our clients, when you come on with us, you never have to do another thing for state unemployment. We do everything, up to and including attending a meeting, a hearing on your behalf. And anybody who has any experience with state unemployment hearings knows that you pretty much, it's a sure bet you're going to lose if the parties that were not involved in the state unemployment transaction do not attend the meeting. So that is a situation where, the reality is we're not going to say in our service agreement, we're going to do everything for you. We're going to list the individual components of what we're doing.
Right. And I failed to mention earlier, so if you have a question about anything that we're discussing, you're welcome to use the chat feature, and we'll try to answer as best we can. However, remember today, whether you're a client of mine or not, I'm not your lawyer. I'm just an informational provider, and so is Gene. And we don't want to get into questions that might waive any kind of privileges or get too technical into specifics, but we'd be happy to try to answer some general questions that may appeal to everybody on the call. So with that, Gene, can you give us sort of a life cycle of the contract? I love this slide, and I'd love to kind of get your take more on this, because not being in an operational position, I don't really have that perspective as well as you do.
Yeah, sure, absolutely. So this is very important stuff, because this is where PEOs get themselves in trouble, where we're not really paying attention. We get the CSA signed, and then we don't pay attention to what happens from there. And so let's talk about so ensuring that anything that's been sold in this contract that's not part of our, anything that's sold that's not part of our main services, we want to make sure that that is in the contract. So for example, let's say the client decided, our sales department convinced us that the client should have, I don't know, recruiting services. Well, there's probably not something in our contract that covers what we're all going to do in order to help recruit on their behalf. So we want to make sure that we have some process in place where, whether it be a checklist, whether, I know a lot of my clients use Salesforce, where they have the components of the sale in Salesforce, and it automatically populates and brings the information to operations, so operation can check that and make sure that the CSA is proper. And so we want to make sure that our CSA, it covers what we're actually doing. And then we take that to, well, what systems are we using for our CSA? So we go to Gordon. Gordon prepares a draft CSA for us. And now what are we going to do with that? Are we saving that in a PDF? Is it going to go into Salesforce? Is it a Word document? And once it's created, we need to think about how we're terming it and numbering it, right? Because the contract in 2022 might look very different than the stock contract in 2025. So we want to make sure we know what contract each of our clients have, whether it be an iteration number or a date. And so we can make and outlining maybe on a spreadsheet. I always like to do it on an Excel spreadsheet, outlining the name of the client, the contract date, what version it is, and anything in there that's out of the norm. Now, some PEOs take it further and they put all the revenue components in there to look at. Like, so if you have, let's say, an automatic 2% increase every year, this would be a good outline for your finance and accounting people to be able to look at. So back on that, how are we saving it? We're saving it into a PDF. And then what's the timing of the CSA? So we have the CSA. It's going, we've gone in, we've put the client name and made any changes necessary. When I say changes, not changes to the CSA, meaning putting the date, any additional, if we're picking and choosing certain services or costs, maybe there's a cost differentiation. And then when are we giving that to the client? Because some clients want to see your CSA before they sign on the dotted line, or I'm sorry, before they even say whether or not they're going to become a client, right? And you have to think about why they want it. Is it lead time because they have to give it to an attorney, or is it because they're going to take your CSA and give it to their broker, and their broker is going to go to another PEO? Like, what's going on here? So you have to know what's my position. Then moving forward, knowing what department provides the CSA. So what's your process? Who manages the CSA? In a smaller PEO, it's hard because you don't have, let's say, a compliance department. So who is managing the CSA? Who is making those changes? Who's providing it? And if are we allowing changes to the CSA? And if so, what's the process to have that approved? And then again, what systems are we sending it out to our clients on? Do we have a secure site to put it on where they can pick it up? Do they have a secure site? Are we comfortable putting that in email distribution? And then tracking, like I said, the spreadsheet. What's the date I just distributed? What's the modification? What's the date I distributed? I'm sorry, this is a different tracking. Forgive me. This is tracking the actual document itself, right? So I have this document. What have I modified it? What date did the client execute it on? When did they return it? Who's following up with the client to make sure we're getting it? To make sure that we can start, if it's a 1-1 start, that we need that service agreement before we process a payroll. And then, of course, making sure we have an executed contract. Can't tell you how many times I've heard, and I don't know, Gordon, if you've come across this, where you're getting ready to enforce the contract, something happened, and we go to look and it's not executed.
It happens for sure.
Yes.
And if you don't have an executed copy, you leave it open that the argument is we never ratified or agreed to the terms. So it can be problematic.
Right. So next slide, please. Okay, and then, so now we've got our clients coming in fast and strong. We've got this spreadsheet. We're looking at, we're keeping track of our CSAs. We're doing well. And now, how do we know who's watching to make sure that we might need to update this CSA? Now, there are things like regulatory requirements where Gordon probably will reach out and say, hey, with PPP, you probably should get an addendum if you're doing this service or that service. But there might be other things where maybe the client was ASO and they've decided to become PEO. Or maybe they've got a worksite employee in a new state that wasn't in the original contract. Or maybe they were on our master health plan and now they've decided to go on a client level, whether that be a health plan or a 401k plan. So what internal controls are we putting in place? What processes and procedures to ensure that somebody knows something is triggering an update to our existing CSA? And is there a cadence that we should be looking for? Should we be talking to attorney and say, and Gordon, maybe jump in here, maybe should we be talking to our attorney and say, every 2 years, we need to look at our contract? Is there a guideline, Gordon, that you recommend?
Well, I think a periodic schedule review is certainly advisable, but there are also reasons to do it more frequently, such as you recognize that your operational model no longer fits what your contract says. You've made some changes to the way you do things. There are going to be changes to laws. There are going to be regulations that come out. There are going to be experiences that you're going to have with a client that motivate you to change the CSA because of a bad experience, or because something slipped with cracks or was vague, or, for whatever reason, you don't like the way it's worded. So yes, sort of a regular review on some interval is a good idea, but anytime you realize, we've got a lot of stuff in here we haven't really done in a long time. We don't do this anymore. Or, we're certainly, if you go to a new state and the state is regulating PEOs, which 42 plus states are doing right now, you may not have a compliant contract that requires update as well. So yeah, I think at worst, and what I do, I'll just throw it out there, is you send it to me, I'll look at it. If I don't see anything that strikes me offhand, I may not want to make any changes. But if you tell me, well, there's some specific things I want to talk about, then I would do that. But every so often it does require a refresher. There's going to be a slide you're going to see here where some of the hot issues that I kind of bullet pointed here, I think those should facilitate some thought as to whether the contract ought to be updated.
One of the things I want to mention also is that we want to make sure that the contract, whenever you're performing the service, and if it's a new service or something you're doing differently, the first question somebody should be asking should be, what does our contract say? Or if the client is doing something they hadn't done before, and there's a charge to be had, we need to ask, what does the contract say? That needs to become a mantra internally, because we want to make sure that we're operating within the guidelines of the contract. And if the contract is wrong at that point, well, then we can make the necessary adjustments. So, so again, if you just go back one sec, sorry, Gordon. Yeah, so just to review, having that database, listing the financial components, list any specific modifications, the executed contract, very, very important. And the other one I wanted to bring up is pre-implementation call with a client. Sometimes, depending on the client, and you be able to kind of gauge this based on the type of client you're bringing in, they may need some one-on-one time to discuss the contract. Some of my clients do it as a matter of course for every new client. Others feel that that's a little bit of overkill with everything else you're throwing at them. But you may want to gauge that there may be situations where you want to have that pre-implementation call. During that pre-implementation call, have the contract conversation. And the one other thing also is, oftentimes a client will come back wanting to make adjustments to the contract. You need to have a talk track to the common adjustments that they may be asking for, that you can change. Like Gordon has told me, this is something that's non-negotiable. This has to stay in the contract. So you might want to have a talk track to those types of items and know things that you really can and cannot change without reaching out to counsel, right? Can I change an amount? Sure, if it's within the guidelines and my PEPM is X and I want to change it to Y, that's a business decision. But if the client is saying they don't want to, I don't know, commit to, I don't know, they don't like the word co-employment, that's just way out there. But, obviously you're going to have to talk to Gordon to figure out how you're going to work around such items. Can you think of something that fits there, Gordon?
Well, I encounter this when a client prospect's counsel isn't as versed with co-employment, and you see it where they push back on the PEO's right of direction and control or hire, fire, discharge, discipline. They don't want you to have that ability, and you have to explain that to be an employer, you have to have these rights, and in some states, it's a statutory requirement to put that in the contract.
Yeah, and to further to that, sometimes this whole question, it's a new scenario for the client, especially when they're not coming from another PEO. So understanding yourself why some of those components, especially what around exactly what Gordon was just talking about, so that you can speak to it to your client before you have to get your attorney involved. And then usually you do at that point. If they're questioning items to that level, you usually have to go back to your attorney.
All right, so let's talk about some of the pitfalls. So I mentioned earlier that we've got a lot of latitude as far as operational model, and obviously your contract should incorporate how you operate. I put together a list of things here that I thought were those pitfalls that I run into with PEOs. And it kind of starts, and Gene's already talked a little bit about this, it starts with the sales cycle, the process with the sales folks. I mean, I joke with some of my clients that you just give the salesperson a PDF of everything. You don't let them change it, because they're going to go and make deals just to placate the prospect because they want the commission. But if you look at the fact that certain promises, if relied upon by the prospect in entering into the contract, aren't made or fulfilled later, it could be problematic. There could be some allegations of fraud or misrepresentations, violation of state fair trade practices, and so forth. And I know if some of you last year I moderated a webinar on this for NAPIO, but it's out there if you're not careful. So some of the things beyond that, just the fluffing versus the sales promises, is taking on too much responsibility. There's certain things you just don't want to be either primary for, or the employer, or the taskmaster over. There are things that are gray in the law that you don't have to take on, or there are things that operationally you're not equipped to do, then you shouldn't do that. A big one here is the joint employer issue. If you thought that in 2021 employees and the great migration and everything, it was a result of employee empowerment, wait till the Biden administration changes joint employer definition, and you end up where even the ability to exercise control, although you haven't exercised it, results in joint liability. That's a big risk for a PEO. So I'm a fan of being careful in language in the contract that doesn't task you with being a joint employer. So you avoid being the final arbiter or decision maker. You avoid language that says, you do all these things. If the client doesn't do them, you do them anyway. You got to be careful. In some cases, you don't have a choice, like we alluded to earlier. Some states, you have to say that you reserve a right of direction and control, or other language that puts you in a position where you've got to represent those things. But whether you exercise it or not is a different story. Another area I see is taking on too much risk. So not everybody uses like Dun & Bradstreet, or not everybody underwrites or vets, clients or new businesses. I mean, there's a payroll fraud scheme where a newly formed entity calls and puts 2 people on the payroll. Next thing you know, it's 10. Next thing you know, it's 20. And anyway, next thing you know, your ACH money's gone, and you basically just got grifted. So there are ways to get burned if you're not careful. I put some examples in here. If you don't get a guarantee from like an owner of a small business, or a security deposit that covers payroll or admin fees for some period of time, or any other ways of mitigating your risk, that can be troublesome. And again, it's going to be a different lens for every PEO, based on size and based on what you're willing to incur in the way of risk. Another thing folks love to do is borrow from others. Oh, I got this great provision off of CSA I saw of one of our competitors. Well, there's something that we look at which is suitable for your intended purpose. Not necessarily just because the words on paper sound good doesn't mean that actually works in your business model, or that it's meant for you in the intended way in which you want to put it in your contracts. You got to be careful with that. And just because somebody else wrote it and you like it, it doesn't even mean it's really proper or legally crafted in a way that's to your benefit. It may be faulty under state law, for instance. We don't, so you got to be careful when you do that. Gene's already talked about this, making independent changes. There are things I'm not going to tell you what to charge. I'm not going to tell you how many days in advance you should get, or how many days notice to do this, or numbers are I think in your purview. But when you get into certain material issues in the contract, like changing an indemnification is a big one. Before you're going to make wholesale changes, it is a good idea to talk to counsel. So I mean, those are kind of the major things I see. Gene, you have any you want to add to this?
No, I do have a comment on the taking on too much risk side. It's very, we could have a whole webinar on underwriting and making sure that the clients are, valid. But one of the things that has come up over and over with this whole fraudulent scheme is two parts. Number one, they're always in a rush. They have to do this quickly. It has to happen very, very quickly. And number two, it always seems that they want pay cards. So this is totally off topic, but it just came into my mind. The other thing about making these changes, when we were talking earlier about if you're going to make any changes, we want to make sure that these are tracked as well on that spreadsheet that I mentioned, because anything that takes it away from being your stock contract, if you will, is something that's going to happen when you update that contract. You want to make sure that maybe whatever it is that's new law or new change isn't contradicting something you previously changed without the knowledge of counsel. So you want to track it so you can go back to it at some point.
Right. And that brings up two other thoughts before I move to the next slide. One is if you use multiple versions of an agreement, as opposed to, like for instance, you want to use a state specific one for each state versus using a single agreement, you got to make sure you're using the right one. And the other is, if you have clients that have been with you a long time and you've made some rather substantial changes to your contract, you want to find a way to re-up them under the new contract where you can't change the terms. You're still under the original. So you have to be comfortable with telling folks, and I'm always delighted to be the bad guy. You just say our lawyer came to us and said, we got to make these changes. This is what we got to put in there. Not that, we asked you to come sign a new one, blame it on our attorney. If you do that, it sometimes softens the blow that they're willing to sign a new one, but it's usually to your advantage. Because you may be doing things because you're stuck under an old contract that you don't want to do anymore. But unless you get change, you're still legally bound to do those things unless the client, somehow understands. Because an oral agreement doesn't necessarily modify the contract. Usually most contracts, and particularly ones I write or review, have what we call an entirety clause. It says basically within the four corners of this contract, that's our deal. Anything we promised you otherwise, it's not in here, isn't part of our deal. So you can't really rely on that wink and a handshake if you want to be engaging in the best practice. So you got to be comfortable getting updates when necessary. All right. So another area, I think we've touched upon this to some degree, but one size doesn't fit all with CSAs. You're going to have to understand and develop language that is going to be compliant with many different states. There is some common thread. Years ago, NAPIO started trying to get model PEO bills passed in various states. So there's some similarities in a lot of states, particularly if you look in the Midwest, but in not every instance can you use the same language in every state. So you got to know that. And in, of course, some states, you're going to have your contract either reviewed by the regulator or approved. And if you have to submit it and it doesn't have the language that's required in the state, they're going to go ahead and penalize you for that. The most visible example of a state that does that is Florida. So when you go apply for your license, Florida actually requires you to provide page and section, et cetera, of where you put certain language in your contract that's required. They have a checklist you have to complete. So if you don't have all those boxes checked, so to speak, you're not going to be compliant in Florida, for example. Another area that creeps up, particularly has really dramatically increased during COVID, is the whole idea of nexus. When is a client doing business in a state? What are they doing that gives sufficient context to where you now are also operating in that state? And wait a minute, are you licensed there or not? This happens. In the easiest example, offices are closed due to COVID. People are in remote work, telework, part-time remote arrangements, and they're working in one state but live in another. And now you have to really find out from your clients, where are all your employees physically working? Even though they report to that office in Atlanta, are they actually in South Carolina somewhere or across the border in Alabama, to where, you need a license in those two other states, because that's where the services are being provided. You got to be aware of that. Another challenge is, in some states, the language or the law requires you to basically bankroll all payroll and pay all your employees regardless of whether the client has paid you first. Now, in those states, you're basically a interest-free loan to the client unless you create measures that are adequate to avoid the scenario. I mean, it's going to happen. If you're around long enough and you're big enough, it's going to happen. But where you don't have to guarantee payment regardless of whether the client pays you, then that's an example of something you would want to exclude from your contract. So
hey, Gordon, a question for you. Are you a fan of a state addendum per state that the client is operating in, or are you more will put the as much language as possible in the contract, and it covers the most stringent?
So generally speaking, I favor using one version, and you have addendums for state-specific provisions, with the understanding that certain things can be drafted in a way that have flexibility that would work for any states. Example would be workers' comp. Not in every state can you offer a master policy, and in not every state does the client have an option to obtain their own policy. That's an example where you could put flexible language in your contract to address that. But there are other provisions in states that you just don't want to put in the master contract, we'll call it. I always have if I'm going to do a single agreement, I'm going to have the home state of the PEO or where their predominant business operates as the body of what I call the master of the contract. Any nuances that might be in conflict or need to be enlarged from what it says in that master would end up in the state addendum the way that I would recommend it.
So to that point, back on that spreadsheet I was talking about earlier, having the states that the client addendums are that exist. So if a client comes up and they add a state later, knowing whether or not we have to get a specific addendum for that state is something that's important.
Absolutely. Yeah, I think it's important to know, and I mean, look, you can put a version number at the bottom of the footer of a contract too, to make sure, it's version 6.1 effective, January 1st, 2022 or whatever. There's other ways also to embed it so that you don't unwittingly use the wrong version. I just think it's a tracking system that works for you, but I like Gene's idea of the spreadsheet. But there are other ways to do it.
Yep.
All right. So also wanted to come up with a list of items that I've been frequently asked of late, and or that have become a hot button for prospects or their attorneys. And a lot of it does emanate around transmission of data, electronic communications, cyber issues, storage of data, where that data is stored. There are a lot of clients pushing back, and they want proof that your vendors are all US based. You can get a certificate of SOC compliance from your vendors that you use, that you have certain protocols in place to maintain and protect the data. What you're going to do in the event of a breach. Do you have liability insurance to cover it? There are a lot of variables here that folks ask in that arena. That is not something that years ago we focused on, because it was more of a paper three-dimensional universe, and now we're more in the cloud-based, and we do less and less paper, and so it's becoming more crucial. And we know there's been some breaches in the industry, and that's probably opened up some more eyes. But suffice to say, you need to review these policies. You need to look at whether you have adequate insurance on top of everything else. The other issue that's come up of late is somehow providing services to what are independent contractors that the client works with. And this can be in terms of cutting checks. This could be access to other PEO related services and so forth. And I just caution, and I want to get into all the moving parts of this because time's not going to allow, but I caution you to understand carefully what your contract says it does and who under the contract you cover. In other words, you're going to call your worksite employees, your covered employees, your assigned workers, whatever term you're using, it's the client employees that you co-employ. That's who you say you service. So when you bring someone who is not under that definition into the fold, you have to ask yourself, how do I service those people under this contract? And it may not be feasible, but most of you know there are other options. There's ASO and there's other ways to do things. I'm not saying you can't provide services to your clients for independent contractors. I'm just pointing out that it's problematic to roll them into a CSA without addressing it in some manner. Same thing with the workers' comp element of this. Most clients are responsible solely for insurance that involves subs or independent contractors. You don't cover those people typically under your policies because, again, they're not a defined covered worker. So that's another problem that I see a lot of clients running into. Oh, we it's Joe individual working out of his house, and the state law says he needs 3 or more employees to have comp, and he's not going to get comp for himself. He's not going to make a claim against his own policy, so he's not going to get it. These are issues you have to work through. I understand the reality of all that, but I also know that if you're mandating this in the contract and you're not enforcing it, it creates some complications for you. Other areas that are hot is who's responsible for doing what. I mentioned I-9s here. E-Verify, you can throw in that category. Who's responsible for that? And the new one, if you haven't heard, is the EEO1 report. The EEOC just came out recently, and I'll give you a quick summary, and I more to come on this, but you can no longer file a single EEO1 report for your clients that are subject to the reporting. You used to be able to use each client location as a separate location. Can't do that anymore. You're going to require to do it differently. Your clients are going to have to register, have their own accounts. They have to give you access and permission. You can prepare and help file, but then the client has to certify, quote unquote. So this is a totally different dynamic, and not every PEO is going to take the responsibility. It brings up complicated questions of if you're the former PEO, but you have data that's relevant for the reporting period, but now they're with a new PEO, or there was no PEO. So there's issues there you're going to have to probably start looking at in your contract as the new regulations are going to probably take place here. They're going to open next month, this registration process for clients that don't have their own account because they were the PEO, et cetera. And then, of course, these addendums we talked about. I've seen addendums for all kinds of stuff. Typically state law compliance, but it's being used for other things. So those are kind of my list. Jean, you want to add anything to these?
No, I think you covered pretty much everything I was thinking of. The only other thing I thought of, and this is not within the realm of the actual CSA per se, and that is when a PEO uses a third party to manage, let's say, reconciliations that might have PII in them or things like that. I remember getting a couple of questions on those items, and I guess that would fall pretty much in your SOC compliance, right? Or in your cyber.
It can. I mean, you can certainly address disclosure of when things are outsourced and to who, and that, like a confidentiality agreement. If you bring a third party in under a confidentiality agreement, they have to agree and be bound by the same terms as the parties to that contract. Same concept here would apply, right? You can add something to their contract that says, to the extent you're going to, either PEO is going to outsource, or client, you want us to work in tandem with some outside party. These are protocols that must be in place, and that third party must agree to those protocols.
Yep, got it.
All right.
Great.
So Jean, This is not, this is more operational stuff, but we all know how to get paid, what you charge. Billing cycles are really important to the PEO's lifeblood. And so I figured, you might as well go over this and talk about what you might want to address in the contract in respect to these items.
Sure. So as Gordon said, he doesn't really get involved with, how much you charge and how you charge and what items you charge for, but they should still be in your contract, right? Whether it's usually like a Schedule A or an Exhibit A, whatever you call it. Defining how we're billing. Is it PEPM? Is it a percentage of payroll, or something in between, maybe both, or some hybrid model? What charges are an additional? Do I charge for new hires or terminated employees? Do I charge if you decide that you're not going to be completely electronic? Do I charge for shipping? A big one that I think should clearly be in your CSA, and it's more for not for making money, it's more for keeping our clients honest, and that is this late submission of payroll, late approval of payroll, late submission of funds, right? Or the ACH fails or something along those lines, so that the client understands that, every time they miss a deadline, we have to spend extra money or extra time. And that's just going to just mess up the process and therefore lead to errors, or, obviously we want to make sure that we're paid. So the other part is to outline our service model. What are we bundled? Are we unbundled? Do we have separate charges for things like EPLI? Can go forward.
Yeah, let me add something you just reminded me of, just real quick, Gene. So I've had a few occasions where folks have questioned, there are states that say wages by legal definition do not include basically like off-cycle or irregular payments, like a one-off commission or like a distribution or single bonus payments. Folks push back on that. Doesn't mean you can't provide that service if it's not included in the wages, but it's not part of your regular payroll cycle. And it does require somebody to step outside the norm and have to deal with it. So I would assume, Gene, that's something that we would want to address too.
Absolutely. One of the other things of this price change, this changing, address how and when I can change prices. One of the items I didn't list here was state unemployment rates. So we had a client that was upset that the state of New York often provides their rates in March, but they're retroactive back to January 1st. And we had a client where it was a substantial increase, and they wanted to know where in the contract it said you can increase my state unemployment rates. Not that you can't increase them, but that you can increase them retroactively. So addressing things like increases, how often can I increase? Saying something like, I'm a big fan of an automatic increase of we are entitled to a minimum of an automatic increase of X% per year. Doesn't mean we have to, but it's in there, so we've addressed it. When our comp renews, when our premiums increase for benefit plans, state unemployment, EPL, just something that's addressing the fact that when and how I can increase these rates, because they don't stay steady. And the same thing with admin fees. And then define payment terms, right? You are going to pay me 3 days in advance via ACH unless you have a security deposit, or you pay by reverse wire, in which terms you can pay 2 days or 1 day in advance. And I alluded to this before. What are the fees for ACH rejections and for late fees, for whatever the late fee is? And then under what circumstances can I terminate my client for failure to pay? Right, that should be outlined in the contract. And I think, Gordon, in your contract, it's there. Clearly
Yep, it's the old, how do you get divorced before you get married?
Yep. Yep. And then moving forward. Okay, and this one will go through fast because I want to leave some time for questions, I think, here. Termination for non-payment. So identify the warning signs. And this also, is part of the whole underwriting our client and understanding. Maybe there are specific verticals that have cash issues. Maybe there are specific startups that we might want to say, hey, we should be collecting a security deposit on until you've shown us that you can pay your bill. Or maybe you've had a client that had some returned ACHs and you turn them into either a reverse wire, a client wire, or you require a security deposit. So identifying these warning signs as they're coming due. The client has returned ACHs. They're losing key staff members. They're suddenly decreasing or lowering the wages or what they're contributing to the employee's total compensation package. These are warning signs that everybody in the operation, whether that be a payroll person, an HR person, they should be aware of, and they should be bringing to your attention so that we know that, hey, there might be something going on here with this client. We may be careful about, the fact that they're a legacy client and they only pay us one day in advance on an ACH. Well, maybe we need to start thinking about changing that to the 3-day rule, which will cover us should an ACH fail. And then once non-payment is identified, you've got to get on top of that right away. So who's contacting the client? Do we have another means of getting funds? Is there a security deposit? Is this a one-off, or is this an ongoing issue with this client? And then, understanding the law in each state regarding, listen, you might have a returned ACH and the employees are all in California. It doesn't matter that you don't have that money. They've got to get paid on, I think it's, I don't know, Gordon, 5 p.m. on pay date, right? And so it doesn't matter that you don't have the money. You've got to pay them. And the same thing with, especially, I'll let you talk to this, Gordon, a little bit, but, for CPEO, it doesn't matter. The statute says you're responsible for the payment of taxes and the payment of wages.
That's right. Yeah, I mean, you can't circumvent that. Again, it goes back to underwriting, and you need clear mitigating measures as well as rights to make you whole if in the event you end up having to write a check to the IRS because the client didn't remit to you the funds, or if you have bank fees, or if you've suffered other damages, right? If you don't address that in the contract damages, including attorney's fees, aren't typically recoverable in what we call the American rule. We don't have a loser pays. So there's things you have to address in a contract to try to recoup what you're going to outlay to put yourself back where you belong. All right, before I go to the next slide, I guess one other thing I was going to mention too is on my list of things I had forgotten about is some banks that engage with PEOs are requiring language in contracts now to deal with NACHA rules, the clearinghouse rules. I've seen and I've had trouble trying to keep it on the simplistic side in some cases with certain banks. So if you run into that, you should definitely add something. It doesn't hurt you because from a practical standpoint, you've already sort of agreed that you'll comply with banking laws by virtue of using the banking system to, facilitate back and forth with your clients anyway.
Yeah.
I mean,
banks don't consider a PEO, don't require a PEO to have NACHA audits or to self-audit for NACHA purposes, but on the ASO side and the payroll only side, we're seeing it more and more. I agree with you.
Yeah, but I've also had banks say, well, you do PEO also, we need it in all your contracts because your money's flowing through our bank. And sometimes it's the smaller banks, I find.
Mm-hmm. Yeah, and one of the other things on another topic that I wanted to mention is in terms of, I'm not picking on salespeople at all, but one of the things that's a good idea to do is maybe join a call with the sales team when they're talking to a prospect about the CSA, right? So we're very close to closing, and maybe understand what they're saying, which will help to give a better context to what's going on out in the field. I'm a big fan of understanding, how that client saw things before they walked in the door. And it might help to help you, whoever's in charge of the CSA, make some changes to your internal processes to be able to better support sales when they're going out and if they're the one who are providing the contract.
Those are good observations. Folks, as the slide says, this is the time for questions. If you have a question and you want us to answer it, please put it in the chat box now. If not, I guess we could go with some closing thoughts on for both Gene and I. All right, I'm not seeing any questions as of yet. So obviously the takeaway here is there is a lot of legal component because it's a formal legal contract, but at the same time, there's wiggle room to incorporate terms that are palatable and adequately represent your business model. There's no you have to put this in your contract because another PEO said so, or they put it in their contract. Not everything is mandated by law. It's a matter of comfort on how you do things. And I've touched upon certain things that are not necessarily required to be in a contract or that could be assigned to the client. You could do shared duties. Every client that I encounter does things differently. I mean, there's a common thread because you're still by nature a PEO, and a PEO still has to do certain things. But folks do things in a wide array and manner, in my experience, and it's not right or wrong. It's back to what I called that chocolate and vanilla. So, but just be sure that you periodically understand what your agreement says. That being said, I don't want you to give legal advice to your clients by saying, well, here's what the contract means. Let them independently determine what it says. Oh, and we have a question. Inquired and interested reader writes, Dear Gordon, if you ever make a mistake when having your CSA signed and executed for a client start date or any issues, concerns, well, okay, if you're asking anonymous person about backdating, if it's an inadvertent error and the party's meant to be bound and effective on a certain date, there is nothing wrong going back and filling that date in. If, on the other hand, you're using it, for instance, to gain some tactical advantage because of some change of the law and you want to push the date out to look like certain activity didn't occur in the prior calendar year, for instance, or other, because this happens a lot in commercial contracts where there's sales, like a sale of a PEO, for instance. You don't want to do that. But if it's an inadvertent mistake, you can go back and fix it and have things just amended. All right, we have another question. How do you manage expectations, demands of salesperson as you're negotiating terms with their prospect? Gene, why don't you take that one? It's an operational question.
Well, it depends on how much leeway you're giving your salesperson out in the field. I mean, there have been times in my career where I've had to say, I'm sorry that your salesperson sold you this, but we can't do it, right? We can't, it's not within the realm of our contract.
Well, and so I've had clients call me and say, oh, we got a prospect and they're in these 18 states, but we're not in all of them. We're only in 15 of them.
Right.
That, to me, there's only two answers. Either in those 3 states, if they require a license or a registration in advance of co-employing, then you can't do it. Or you offer a temporary solution like an ASO in those states, if the client will accept it. And then you get licensed in the interim. I don't think you can skirt the law because there is no state that says there is a de minimis exception if you only have one person in a state or, 2 people. Every PEO statute says if you're going to provide the services to even one person, you've got to have that license. And so that, I guess, is part of an example where I would want to manage don't sell, or the prospect process should come to a halt when you figure out that they're asking you to service folks in states you're not operating in yet. You're not set up for.
Yeah, I mean, and I think back to the original question, I think the issue that or the way to address it is you have to have You have to have parameters by which the salesperson is allowed to promise certain things, right? We had a list of every state to Gordon's point, that we were registered in, and if this prospect was going to be in a different state, we had to be informed in operations so that operations can say, hey, it's going to take X number of months to be registered there, or we can't get registered there because of X, Y, Z. There are other items, the hardest part about the salespeople is they want to do everything, right? And so we kind of had to manage by literally having a guideline by which they were allowed to sell. As crazy as that sounds, it's the only way to do it.
It makes sense. All right, we got one more question and probably just time to answer this real quick. So being asked to share our biggest CSA catastrophes, I suppose. I've had a couple of clients who floated payroll for pay period after pay period to a tune of more money than they had and could afford to bankroll. So there's that. You basically put yourself out of business by not cutting that client off at the first instance that the client was showing they had an insolvency or a financial problem.
I know of a situation where the PEO went back and retroactively terminated the client because of failure to pay, and was sued by an employee who lost their insurance, who actually was a co-employee, let's say through the 15th of the month, and the PEO went back for failure to pay retroactively to the 1st of the month. And, it was just a suit for the payment of the COBRA. I wouldn't say that was crazy, but that's one of those situations where you have to be careful.
Yeah, I mean, there's other scenarios, but it's more the client failed to comply with the contract, like reporting a worker who started on a Saturday, but of course the PEO is closed, it's on the weekend, and Monday morning they report an accident and the PEO never onboarded the person. I've had that happen too, and the PEO got stuck with a comp claim and there was no knowledge of this person.
And then we don't even want to, we could spend a whole hour talking about EPL claims that come through based on the PEO told the client to terminate someone who had done something that was discriminatory or otherwise. They didn't, and then the person went out and did something horribly egregious, posting something on social media or some other situation, and now the client is being sued and the PEO is brought into the suit. But that's, we could talk about EPL forever.
Yeah, maybe that's another topic for another day, Gene. Well, we appreciate your attendance. I want to put this up for you before you jump off. This is Gene's contact information. That's Gene on a bright sunny day, being her normal self in the photo. And this is my information. If you're not on my e-newsletter, I do a weekly Friday e-newsletter. If you want to get on that, you can email me. I will add you or any coworkers that you have. I do at least quarterly webinars. There's Gene again. Gene and I like to collaborate because we have good perspectives, and we enjoy giving back to our great clients and friends in the industry. And we look forward
likewise, if any of my clients have a topic that you think would be great for the two of us to present on, we're happy to, we'll put something together and provide some good value to everyone. I, unlike Gordon, do not have a YouTube channel, but I think that anybody can join his channel. So you can hear me on Gordon's channel.
Yes, all my prior webinars are available there in living color. And if you have any feedback on this webinar, any reason that you had questions, concerns, positive feedback, we want to make this better and improve every time we do it. So if I don't hear from you, I don't know how to do that. So would appreciate that. I appreciate you all taking the time out of your day to listen to us. And I certainly look forward to doing this again in the future and hopefully seeing some of you in the coming year as well.
Absolutely. And any follow-up questions for either or both of us, feel free to email us.
All right, everybody take care and have a good rest of the day and a good rest of the week.
Thank you.